All rise. Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument, and I'm going to probably butcher the name, but I'll try Lakridis. Is that right?
That's correct, Your Honor.
Lakridis v. Meekin. Did I get that right?
That's right.
Yes. Wow. All right. Excellent. Our case number 1, CA-CV19-0473. We got 20 minutes for each side. So appellant, if you want to reserve some time, you may do so, but it's up to you to keep track of it. We don't keep track of it for you. I believe we've got the clocks where they'll be able to see them in front of you. We've set up council table there. If you want to take off your mask while you speak, you can. That's entirely up to you. You can leave it on also. The mics are there, so you don't need to use the podium. You can stay there at council table. We record these arguments, and I believe we live stream them on YouTube as well. So when you begin your presentation, please identify yourself and who you represent in case the millions of people who are watching want to know who you are. I think I've covered everything. Oh, we conferenced the case this morning, and so we've read the record, or reviewed the record, and have read the briefs. So we're pretty familiar with the facts. Just keep that in mind while you present your argument. And with that, counsel, you may proceed.
May I approach the podium, Your Honor?
No,
Okay,
we got the
sir.
mic set up there,
Okay.
so we don't have a mic at the podium anymore.
And good morning. This is Mark Horn and Todd Sloan on behalf of the appellant. Todd will be turning pages for me today if I need to read because I cut the tip of my finger off yesterday.
Oh,
But I'm okay now. We're here today.
it's up to you. I would just say we'll probably pick you up better on the mic if you sit.
Okay.
If you want to stand, you're free to do so.
We're here today because the system has failed the appellant. It has consistently and on multiple occasions erroneously and unfairly deprived him of the opportunity to be heard. Did it the first time when it dismissed his case on the basis of statute of limitations erroneously at the request of the defendants. This led to a 15-month delay in the case, during which my client not only vigorously prosecuted his case, he won on appeal and overturned the trial court. So that was the first time. The second time the system failed appellant was when the trial court allowed the attorney for the appellant to withdraw 1 day before it dismissed his case.
Well, hold on. That's not completely fair to the trial court. Judge Morales issued an order saying, I'm putting this on the inactive calendar, and if you don't file something between enlisted the things that are required under the rule, if you don't file it by this date, I'm going to dismiss the case. Putting your client clearly on notice that if they didn't file something by that date, the case was going to be dismissed. Correct?
And that's correct, Your Honor, but I believe that is also not a completely fair portrayal of the circumstances and the obligations of the trial court given the circumstances. Prior to the dismissal of the case, and admittedly...
What was filed before the notice, the dismissal notice date?
With regards to what the court ordered?
Yeah,
Nothing was filed before the date given by the trial court, Your Honor.
nothing.
Nothing.
Did the system fail, or did his counsel fail?
Well, Your Honor, the reason why I used the word system instead of the trial court was because I believe there was probably some failure on behalf of the prior counsel as well. The problem is...
Some or all?
Some. And part of the problem, Your Honor, is that the prior counsel informed the court that my client had suffered a traumatic brain injury that led to problems that are not ordinarily faced, that the trouble with his
He notified him
injuries,
after the deadline.
That's correct, Your Honor, after the
Counsel,
deadline.
is there any reason why appellant could not have filed the same substance of the pleading prior to the deadline and say, I need more time, I need you to continue on the inactive calendar because due to my client's traumatic injury, we are not able to communicate as effectively, or because I need to get off this case, or whatever the case might be, before the deadline?
Well, there are 2 points here, Your Honor. One is we specifically requested an evidentiary hearing so that we could ask the prior counsel about that and get this evidence out before the court. The court deprived the appellant of the opportunity.
Hold on. You need an evidentiary hearing for that? Why can't you just get an affidavit from counsel?
Well, he's prior counsel. He's no longer counsel for the appellant. And at that point, he's a potential adversary to the appellant.
Okay, but now we've moved beyond what my question was. What prevented appellant, as represented by counsel, from filing that document prior to the deadline and saying we cannot meet the current deadline the court has set?
Well, Your Honor,
Was there anything preventing it?
according to the prior counsel, my client's injuries were prevented it and had caused some delay due to circumstances that were not ordinary due to his injury. I believe at that point, the court has at least a duty to further inquire as to the circumstances before it dismisses the case.
Maybe I'm not asking the question correctly. I'm not asking about post-deadline proceedings that could have been had. I'm asking prior to the deadline, why could not counsel have said, I am having a real tough time with this deadline. I'm having issues with my client and I cannot meet this deadline. Why could that not have been done? Or are you telling me that it could have been done?
What I'm saying, Your Honor, is that an evidentiary hearing would have allowed us to further discover that. Why was he not able to file before the deadline?
Okay, so you're telling me you don't know why or whether counsel could have filed prior to the expiration of the deadline?
That's correct, Your Honor, because the court did not allow an evidentiary hearing for that to be flushed out, and it allowed the attorney off the case 1 day before it dismissed the case. There's no excuse, in my opinion, for the trial court's failure to at least allow a new attorney to come on board before it dismissed the case. Clearly, from the filing, there was a conflict between the attorney and the client at that point. So, who knows why he did not do it before the...
And this is referring to you specifically, but did your client allege post-dismissal in the Rule 60 motion any reason for why counsel did not file prior to the dismissal deadline?
Well, Your Honor, we've...
I need you to answer my question.
Of course, and I'm trying to answer your question.
Okay, so it really was a yes or no. Did
Right.
you allege any?
Yes.
What did you allege?
What was stated by the prior counsel and that the delays due to
Well,
his...
that's not the question. The question is, was there any impediment to counsel filing the motion to continue or a motion to withdraw prior to the deadline? Was there any impediment listed in the Rule 60?
Yes, it was what the prior counsel had alleged with regards to his brain injuries leading to delays that could not be avoided.
And that stopped counsel from filing anything prior to the deadline?
That's what...
A motion to continue, for example.
That's what prior counsel had said in his filing to the court, and we needed to flush that out further with the prior counsel at an evidentiary hearing. And Your Honor, I believe, if I may just make this point real quick, this point is not the be-all, end-all of the case. Excusable neglect is only one of the reasons why this court should be reversing the trial court's opinion. But in that regard, with the excusable neglect, we believe that there is further to flush out with an evidentiary hearing. And if I may quote a very important quote from the Jepson case, which is 152 Arizona at 183, our Supreme Court said, where the passing of the statute of limitations transforms a dismissal without prejudice into one with prejudice, trial courts should take an especially hard look at the actual circumstances of the case before it. The trial court completely failed in that regard. It should have, with the allegation of a conflict between counsel, brain injuries that prevent my client from day-to-day things to assist the prior counsel. These circumstances require the court, at the very least, to allow time for a new counsel to come on board that doesn't have a conflict and to look into these injuries, brain injuries, and not leave him hanging without an attorney the day his case is dismissed.
But counsel, aren't you there describing more a situation where your client has a cause of action perhaps against his counsel as opposed to failure by the court, which is trying to manage its calendar and did not receive any information as to why dismissal should not be had, no timely information?
Well, I believe whether or not the appellant has a cause of action against his prior counsel is not a relevant consideration to the issues. At least I haven't seen a case that...
Well, it is if you're trying to shoehorn into this case when really the matter lies somewhere else.
Well, I'm not sure that it does, Your Honor. I believe that the court had an obligation to look very specifically at the facts. It left him without an attorney in the midst of allegations that he's suffering from a brain injury, and there are mental impediments to his ability to assist and prosecute his case. The court's got to look into that.
So then is it your position, first of all, is it your position that the court should not be permitted pursuant to Rule 38 to, when a case is just not moving forward inside the court obviously doesn't know what's happening outside its doors, but is it not the responsibility of the court to reach out to the parties and set deadlines and say, if there's no activity, this specific activity, then this case will be dismissed? It's on the inactive calendar. Is that, you concede that's proper?
Of course, Your Honor.
Okay.
It is proper under many circumstances, but not all circumstances.
So then is it your position that the court then needs to leave sort of a window open outside of that deadline in the event that there's good cause for why the parties don't come forward?
That's correct, Your Honor, and there's a...
So basically what you're asking is that we rewrite the rule. Because the rule, Rule 38, it says the court must dismiss. If the following doesn't happen, you either file the joint report or prior to the deadline, you file a motion to continue showing good cause. That's what the rule says. So you want us to read it, not the must dismiss it. You want us to read if there's good cause to dismiss it. Or without good cause, you're going to dismiss it.
Your Honor, it's very clear from the case law that it is not a per se matter. The court does not have the right to dismiss the case without even
In what case is a Rule 38 case that specifically says what you're just
Well, Your Honor, we don't believe this is a Rule 38 case. This was not put...
It was dismissed under Rule 38. What are you talking about?
Well, it was dismissed because we failed to abide by the court order. This is not an administrative dismissal based on it being placed on the inactive calendar. This was a...
So what rule was it dismissed under?
This was dismissed under because the appellant's counsel did not comply with the court's order to file a joint report and scheduling order.
Under what rule?
I believe it's under the court's inherent authority to dismiss a case
So
when...
you're saying the specific rule that governs this didn't apply in this case?
Correct, Your Honor. And we believe that the standards of Lewis versus Lewis apply, and we've cited that in our briefing, to where if the court is going to dismiss a case for failure to abide by its order, it must first hold an evidentiary hearing to determine...
Isn't that a sanctioned case under Rule 37?
Right, and well, that's a sanctioned case, period, I believe. That applies to any circumstances where a party is being sanctioned for failure to abide by a court order.
But this wasn't a sanction, was it? I mean, this is just simply a Rule 38 order. There was an order. You said you're going to have to file it. If you don't file it take certain action with a certain amount of time, the court must dismiss it.
Well, The court put it on the enacted calendar pursuant to its own initiative after it was reversed on appeal and the case had languished for 15 months. This is not a case where it was automatically and then administratively put on the enacted calendar and then dismissed administratively. This is a case where the case was dismissed because of failure to abide by the court order.
Are you saying that it was improperly put on the inactive calendar?
I wouldn't say improperly, but I would say not pursuant to the rule under which it wasn't dismissed administratively under Rule 38.
Or under the usual
Right.
circumstances? Well, was it improperly placed on the administrative calendar? On the dismissal calendar, pardon me.
I wouldn't say improperly. I would say that the court's having to be reversed on appeal and the languish of 15 months contributed to the court's decision to put it on the enacted calendar for dismissal.
Do we get to look into the mind of the judge and say are you able to prove some bias? Is that what you're saying? They're saying there's some bias on the
No,
part of the judge?
We're not saying there's any bias, Your Honor. We're saying that the court did not look carefully at the circumstances before dismissing the case.
It's a different judge, for one thing.
I believe it was the same judge, Your Honor.
No, it wasn't.
Okay.
Judge Gentry Lewis filed the original, granted the first one, and Judge Morose did the second one.
Yeah, and regardless, we believe that the 15-month delay, because of the appeal, contributed to the court's decision to say, hey, this thing was filed,
So Judge
several months
Morose-
ago.
Judge Morose is protecting your friend, is what I guess what you're saying.
No, I'm not saying that at all. I'm just saying she erred. She erred in not carefully considering the circumstances. She erred in not holding an evidentiary hearing in light of allegations that the appellant was suffering from serious brain injuries and could not effectively assist in the prosecution of the case. She erred.
So your position is that when she set it on the inactive calendar, she needed to give it a special consideration given the circumstances of the case. Is that
That's
fair
correct, Your Honor.
characterization?
Before dismissal, and we've cited a case in there that says, the application of these of the theories contained in Rule 60, you don't have to wait for dismissal before the court can exercise its power and not dismiss the case. It was brought to the court's attention that there were irreconcilable differences, and I quote, irreconcilable differences between the appellant and the attorney. That is the attorney that missed the deadline to move to have it continued or to file the joint report. It is, I can't understand, and no attorney I've talked to can understand why the court would not allow him to at least retain a new counsel he didn't have a conflict with prior to dismissing it. What he said was, what my prior counsel told the court was, we have irreconcilable differences. I have to withdraw. He's got serious brain injuries to the effect where there are circumstances that we don't ordinarily face. You need to let him have new counsel.
But those are all things he could have said and knew well on April 21st. That's where I keep getting hung up, is that everything he says explains why the case has drug on, but it doesn't explain why he didn't respond prior to April 22nd.
And that's a good point, Your Honor. But I think the good point that you just made for our side of the case is that it does explain why things may have languished. So when you're talking about the other bases for having either the decision reversed or what we prefer is the saving statute. Let us refile it. Part of, basically what those cases say is, or what the statute and the cases say is that if there's been good faith, an attempt to diligently prosecute the case, and justice, the demands of justice require it, the court can save my client from the statute of limitations and allow him to refile. And I think that there is a very thin line between the saving statute and Rule 60B-6 that allows for the court to set aside a judgment for any other reason not provided for the other rules that is just and proper. We believe that this case could squarely fall into either of those two. The court did not exercise its power to, or it was required to look at the case carefully, and it didn't. It consistently refused to allow him to tell the court his side of the story with an evidentiary hearing, and to examine his prior counsel, who said that there were irreconcilable differences. We believe that if there were ever a case for the court to exercise its power under the savings statute in Rule 60b-6, this is that case. He's got, the record below was that he was facing a lot of trouble because of his brain injuries, and that led to delaying the case. He vigorously prosecuted his appeal and won his appeal. And it's simply, this is not the circumstances where the appellant should be stripped of his rights to sue the defendants after they caused serious brain injury for life. It was a very, very grave decision that the trial court made, and the trial court did not correctly look at the case in detail and allow us to present our sides of the story with an evidentiary hearing. So, at the minimum, I believe the court has to reverse trial court for an evidentiary hearing so that he may be heard. Finally, give him the opportunity to tell his side of the story. But we also believe that the best course of action would be to give him exercise the power under the savings statute, because we don't want to go back to the trial court in front of the same judge and have an evidentiary hearing on this, and the parties, in the meantime, even more times going by, more attorney's fees. The court, under these circumstances, can exercise its power under the savings statute and give him the opportunity to refile. Alternatively, Rule 60b-6, there are other circumstances here that don't fall under any of the other Rule 60 numbers. This is a perfect example of where other circumstances exist and that justice requires the court to exercise its power and overturn the trial court.
Counsel, thank you. I think you're out of time. Appreciate your argument. Pelly, you may begin.
Your Honor, this is Justin Ackerman on behalf of Massachusetts Mutual Life Insurance Company. Your Honor, this is the case where the court affirms the trial court's decision because there is nothing extraordinary in this record that would warrant the type of relief that is now being requested on appeal. The only thing that is surprising in this record is the utter lack of diligence by plaintiff's former counsel in pursuing this case. And I'd like to sort of correct a procedural issue that is being repeatedly sort of flaunted to this court, and that is that this case languished at its initial stages and the initial complaint that was filed on February 23rd, 2016 because of an appeal. What I think needs to be brought to the court's attention is that that appeal, first of all, that complaint was only served on one of the named co-defendants, Meekin, not on Massachusetts Mutual, not on any of the other named defendants. So that appeal only involved one defendant, and it was pursuant to a 54B judgment. So plaintiff could have pursued his case at any point in time against Massachusetts Mutual, regardless of that appeal. So once the appeal is remanded, we are now several years down the line of a case that's just languished, at least with regard to my client. But once the case is remanded, it sits there for 10 months and nothing is done. There's been change of counsel that's happened once or twice in the case, but that's it. That's all that's been filed before the court. And you have a court issuing a minute entry saying, by this date,
I thought there was a motion to amend the complaint.
there was a motion to amend the complaint, which was granted, and then plaintiff never actually filed an amended complaint. And there's many records in front of this court, email correspondence between trial counsel in this case and plaintiff's counsel saying, what is going on? Are you going to file your amended complaint? Can you send me a copy so I can start preparing an answer? Like, let's get this case going. It's repeated prodding by defense counsel, which is unusual. for plaintiff to pursue his case and nothing. And so you have a court order to file something by a deadline pursuant to Rule 38, as the court is required. You indicated very well, Your Honor, the must language in there required the court to do this. And then you have plaintiff's counsel letting that deadline pass. And
Counsel,
then,
so
go
the
ahead.
motion was filed 9 days after the deadline. What prejudice is there to your client if the plaintiff is allowed to go forward? I mean, it's not as though he's coming back months later asking for this continuance and for some additional time.
I have a twofold answer to that, Your Honor. One, I don't think prejudice should be the consideration at that point because the rules are mandatory. And after the deadline is passed, the court had no ability to consider prejudice because the deadline had passed, nothing had been done, Rule 38 is clear, the court must dismiss. So I don't think prejudice is a consideration at that point, the time had passed. And my second answer to that is what I had sort of indicated before. This case had happened, the incident itself happened in 2014, February of 2014. At that point now, we're looking at May of 2019, almost 5 years later. I mean, I know it is an often quoted phrase before this court, but witnesses' memories fade with the passage of time, and you have what is alleged to be a slip and fall incident 5 years ago. It is extremely prejudicial to defendants to have a case go this long without having any discovery being conducted. So that, I mean, if to the extent there is prejudice even being considered, which it shouldn't be, that's the prejudice. But under Rule 38, this court clearly dismissed and properly dismissed this case. Now, plaintiff's counsel is adamant that a hearing should have been conducted. Well, a hearing was never requested, not at the motion to continue stage. In fact, the motion to continue itself was a perfunctory motion, again, that was late. And it wasn't until the court gave plaintiff another chance to explain what was going on, where plaintiff brought up for the first time in any correspondence, either within the court or even outside the court. I would note to the court that none of the correspondence that is in the record between counsel ever indicated issues related to TBIs or scheduling or communicating or anything like that. But now in this reply, essentially, that plaintiff filed in support of his motion to continue, he raises this TBI issue with no supporting evidence, affidavit, anything. And now plaintiff argues on appeal that, and doesn't request an evidentiary hearing, doesn't ask the court to apply the savings statute in those documents. And now plaintiff is saying the trial court erred in not holding this evidentiary hearing, which...
Well, the way I understand it, there actually, he requested, or he's saying that he should have gone to hearing twice. He should have perfunctory got a hearing before the dismissal under Rule 38 because of the language that you should have a hearing for a dismissal under Rule 37. And then the second time he should have had a hearing is when he filed his Rule 60 motion. Now, when he filed his Rule 60 motion, he did ask for it.
Yes.
But, correct, was there any evidence presented in the Rule 60 motion that would indicate there was an impediment to his lawyer in filing a motion to continue pre-deadline versus toasted?
Absolutely none, Your Honor. The lawyer did not need client permission to save his case, especially when he had already been hired initially by plaintiff's counsel, or by plaintiff, I'm sorry, and clearly had inherent authority to file a very simple procedural motion to continue the case for 90 days on the court's active deadline within the time prescribed by the trial court. And there is nothing that prevented counsel from doing that. And I would submit to the court, there is nothing in the pleadings that even indicated counsel couldn't effectively communicate with his client if he had to, which he didn't, to get that permission. All that is in the record before this court, which is repeatedly cited by plaintiff, is that to the extent that there were delays, there are certain days in which it is difficult to communicate or for plaintiff to understand his case, which by the reverse of that would mean there are days where he would understand that. And again, this is I think a test of good counsel going before a trial court and saying, Your Honor, I'm having difficulties communicating with my client. I need another couple days to file a motion, to ask for leave, anything to go before the court before this deadline occurs, given the required language under the Rule 38, to give the court some notice that there is issues going on and that something needs to be done. It just simply did not occur in this case.
Does excusable neglect apply to a Rule 38 dismissal?
No, Your Honor, I don't think it does. And there's none in this record. And it's not even argued on
I'm not asking
appeal.
whether there's any in the record. So if the counsel had, on May 1st, when he filed his motion to continue, had said, my paralegal who's responsible for calendaring these deadlines blew it. And she's been reliable in the past, but in this case, she missed the deadline. And that's why we're 8 days late. Would that have been sufficient to avoid dismissal under Rule 38?
Under Rule 38, no. Now, if the court is considering a Rule 60 motion after the fact, it could potentially be something the court could consider. Again, though, that is not in this record, and I would also note to the court, there is absolutely nothing argued under Rule 60b-1 in any of the appellate briefing. In fact, if you look at the reply brief, it only focuses on 60b-4 and 60b-6. That argument is long waived in this case and under the Panzino case, and as my briefing goes over, that is not an argument that can maintain.
I thought they said in the reply brief that Rule 60b-1 was self-explanatory or something.
I don't think it is, Your Honor. I think the court, there is some language in their reply brief about how this court doesn't need a treatise on Rule 60. I think personally that if you're the appellant, you should be giving the court a treatise on the rules that you think are applicable and how they apply to the facts of the case. So there was no abuse of discretion in dismissing this case on its initial calendar. There was no abuse of discretion in not holding a hearing. In fact, there's no case law provided to this court about having to hold a hearing to the extent that plaintiff gives case authority about notice and opportunity to be apprised that this case could be dismissed. Well, sure, he had plenty of notice and opportunity through the court's orders and at least 2 occasions to brief the issue before it was actually dismissed.
Why would 60b-6 not be sufficient to raise up essentially an excusable neglect in missing the deadline previously on a Rule 60 motion?
Well, Panzino squarely holds that you cannot raise an excusable neglect claim under Rule 60b-6. Well, it's controlling authority.
Okay. But so let me rephrase that then, and thank you for correcting me. If counsel had put something in the motion that would be sufficient to say that there was the cause of the communication breakdown caused him to miss the deadline in some way. So it's not excusable neglect, but it's now more than just I'm having communication breakdown with my client, but I was going to file this, and 2 days before he told me not to because he was having a crazy moment, and then called me on 3 days later and said, what was I doing? I was hallucinating at the time. Something like that. Would that be sufficient under this case to trigger justice requiring under B6?
I would be remiss to even say that because at that point the counsel has a conflict of having to comply with the deadline and his client telling him not to. I think he'd have to withdraw at that point, just as an aside. I don't think that Rule 60, though, could...
So he should have filed something to say, hey, look, I want to file this, but I can't because my client's not letting me at this point. And I almost tell the court that there's this issue going on.
I don't know if an attorney could go that far as to explain sort of that inherent conflict. I think he would just have to say he has a conflict. I don't know, unless the court asked him sort of in a side.
He should have at least filed something to say there's an issue going on here that is the reason we can't comply with your scheduling order. We need more time. Correct.
I've already sort of covered Rule 60b-1, even though I believe it has been waived on appeal. To the extent that plaintiff argues under 60b-4, his basis for that is the non-holding of a hearing. And again, there's no requirement for the court to hold a hearing. So there can be no abuse of discretion when it doesn't, particularly given this record before the court. And then with regard to Rule 60b-6, the court has the Panzino opinion. It also has the Jepson opinion, both of which clearly state that where an action is terminated for a lack of prosecution, relief under Rule 60C is improper, and that controls here. And it makes the same point with regard to the savings statute. Diligence is the key examination under the savings statute. Jepson made clear of that when there had been some other standards, and it came in and said, no, diligence must be the focus here. And on this record, there's no diligence.
Is there any other way in which counsel for the plaintiff could have obtained a statement from the attorney? Let's assume that the prior attorney is now basically at odds because he's probably on the hook for a malpractice claim and doesn't want to cooperate any more than he has to. Other than a hearing, evidentiary hearing on the 60B4/B6 motion, is there any other way they could have obtained a statement from him? Or put that evidence before the court?
I think you could have done an affidavit from plaintiff saying, here's the situation, and I'll swear to it. Boom, 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 boom. Here's what happened. I'm at odds with my attorney. He didn't do the X, Y, and Z. And that is enough to at least have put the issue in front of the court. Again, that wasn't done here.
Well, I was going to say, you didn't have to go that far, do you? Don't you just have to have the lawyer who's filing the Rule 60 motion say, I attempted to reach out to counsel for plaintiff. He refused to cooperate or give me any information. So I need you to hold a hearing so we can subpoena him in to find out why he didn't do X, Y, and Z.
That may be the case, but I don't think that'd give you relief under Rule 60. Again,
No, but at least it would get you a hearing.
I don't think...
Potentially. It would do it in the discretion of the court at that point in time, wouldn't it?
I would say no, Your Honor, because I don't think... Again, I'm going to keep going back to Panzino because at that point, the neglect of the attorney is attributed to the client, and I don't think that the court should be obligated to hold a hearing to allow the client to sort of build their malpractice
Well, not
case.
obligated, but permitted.
Again, I think even under Panzino, not permitted because it is an automatic, I'm not going to say negligence, but his failure to act is imputed onto the client. So I don't think the court even gets to explore why. It doesn't matter.
Does the competency of the client matter nothing at all then? I mean, it sounds as if the allegation is that the client was not capable of making decisions for himself, rational decisions for himself at the time. Wouldn't that kind of pose generally I agree with you that the competency of the counsel is imputed to the client and vice versa, but where there's been an allegation that the client is not competent to, and I'm not sure it's a full allegation in this case, but let's assume it is, doesn't that kind of cause or take it outside of the general holding of Panzino?
I don't think so. No, I mean, the holding of
Why not?
Panzino is extraordinarily broad. I mean, the issue in Panzino is whether the court would apply the positive misconduct rule, which basically means where the attorney completely neglected the client in his entirety. The client should be relieved under Rule 60, and the Supreme Court said absolutely not. So regardless of whatever was going on with the client, so long as he was represented at the time, and there was no facts in the record to impute the attorney's inherent and apparent authority to represent his client, I think whatever the attorney does binds the client. I'll also note that there's nothing argued in the record with regard to a meritorious claim, and that is an absolute requirement under Rule 60 to even bring a claim to seek Rule 60 relief, and the Jepson case makes that very clear. It's not argued on appeal. I raised it in my answering brief, and again, it's not addressed in the reply brief. And sort of for all the reasons I've already described, the relief was properly denied under the savings statute 12504. There was no diligence or vigorous prosecution of this case. I've indicated already the prejudice that my client continues to suffer with this case now, eking on to 6 years. To try and send this back and to do any kind of discovery would just be next to impossible, I would submit to the court. And the one factor that plaintiff may have under 12504, which is that his case is now time barred because of the statute of limitations, Jepson makes clear that if that's the only consideration, then that's not a basis to invoke the savings statute. Unless the court has any other questions.
No further questions? Thank you both for your argument today. We will take this matter under advisement and issue a decision in due course. Thank you.